Whether a joke can be copyrighted is an interesting issue. Stealing jokes is nothing new to comedy writers, yet it is uncommon for comedians to use copyright infringement lawsuits to protect their jokes because of the costs involved. Moreover, due to the difficulty in proving ownership of a joke, success rates in such lawsuits are low. In theory, a joke can be copyrighted, but there are numerous barriers that might not allow a plaintiff to gain copyright protection. We will discuss each of the 5 hurdles a plaintiff must overcome to succeed. The first hurdle that a plaintiff must overcome is referred to as the idea versus expression dichotomy. The plaintiff must prove that the expression was infringed upon, not an idea. An expression must be a specific arrangement of designs or words. Federal copyright laws protect the expression of ideas, but not the ideas themselves. The idea versus expression dichotomy was introduced in Nichols versus Universal Pictures Corporation. In that case, a playwright sued a film company for use of a similar comedic story, which entailed a Jewish man marrying an Irish Catholic woman whose families both disapproved of the marriage. The court in Nichols found that the comedic concepts lampooning the stereotypical characters were ruled to be universal ideas, and thus not eligible for legal protection under copyright laws. To successfully assert a copyright infringement claim, a plaintiff must prove that the expression of the idea was infringed upon by another party. It is the expression of the idea that must be original to the creator to possibly gain legal protection through copyright laws. The second hurdle faced by plaintiffs when seeking copyright protection for a joke is that the plaintiff must demonstrate that the subsequent use of the joke was not an original and independent creation. Many times, comedians tell jokes pertaining to what is trending in news or culture. For example, in their law review article entitled Emergence of Intellectual Property Norms, the authors discuss a joke about the construction of a border fence between the United States and Mexico, and how several comedians in the 2000s used this idea to create jokes. Each of the comedians used the same punchline, asking the question, "Who do you think is going to build that wall?" Yet each comedian told the joke with slightly different spins, altering the joke's introduction. The court found that telling a joke with slightly different words, which in the industry is called a write-around, alleviated all potential copyright infringement claims because write-arounds allowed subsequent writers to claim originality. These write-arounds make it harder for a plaintiff to claim copyright protection because future comedians are placing their own unique twists on a joke, making them their original productions. A third hurdle further complicates a plaintiff's copyright protection claims. Under copyright law's merger doctrine, if there are limited ways to express an idea, the idea will merge with the expression of the idea and the expression will receive no copyright protection. The merger doctrine was first expressed in 1967 in the Supreme Court case of Morrissey v. Procter & Gamble Company. There, the plaintiff copyrighted a contest's rules that involved using the contestants' social security numbers for identification purposes. The court held that the idea of using social security numbers for identification could not be infringed. Protecting a contestant's identity could only be done in a limited number of ways. The idea of protecting contestants' identities had merged with the expression of the idea, which was the use of social security numbers. Consequently, the plaintiff's rule could not obtain copyright protection. A fourth hurdle a plaintiff must overcome concerns the length of time that a creative work or joke is accessible by the public. A plaintiff's original creative work must be permanent enough so that it can be reproduced by others longer than a transitory duration. For example, Olga Lexel, a Los Angeles-based freelance writer, composed a joke and posted it on Twitter. Soon afterwards, many Twitter followers used Lexel's joke as their own and shared it with their own followers. Lexel informed Twitter, and the social media platform removed the offending tweets. A lawsuit did not ensue, but legal analysts contended that even if Lexel had pursued legal action, she would not have been successful. The tweet did not satisfy the fixation element because Twitter removed the tweet within a short amount of time after it was originally posted, and the tweet was not available to the public for long enough for it to be reproduced. The fair use doctrine, codified in 17 U.S.C. Section 107, can also preclude a plaintiff from claiming copyright infringement. This doctrine allows for the use of copyrighted material by another for commentary, reporting, teaching, or research. Whether a subsequent use equates to fair use is determined after weighing the different elements in the following four-part balancing analysis. 1. The purpose and character of the use, whether it is commercial or for educational purposes. 2. The nature of the copyrighted work. 3. The amount and the substantiality of the portion used. 4. Whether the effect of the use on the market harms the current market for the original copyrighted material. The case of TCA Television Corporation versus McCullum focused on the fair use doctrine in a copyright infringement suit. A Broadway play used part of a famous joke, "Who's on First?", a comedy routine developed by American comedians Albert and Costello. In the case, the heirs of the comedians sued the play's writers for copyright infringement. The legal issue for the court became whether the unauthorized use of the joke in the play qualified as fair use. The court held that the playwright's subsequent use of the famous joke satisfied fair use and did not infringe upon copyrighted material. In its opinion, the court focused on the fourth element of the four-prong balancing test. The court reasoned that the Broadway playwrights utilized "Who's on First" in a manner that wasn't intended to and did not harm the market for the original joke. The market for Abbott and Costello's comedic material remained the same, and potential consumers did not stop purchasing these Abbott and Costello DVDs or videos to view this play instead. As a result, it was a fair use that precluded liability for unauthorized use of the copyrighted comedic routine. Conan O'Brien's dilemma: copyright infringement or smooth sailing? In a recent copyright infringement suit against Conan O'Brien, the plaintiff, Robert Kaseberg, alleges that Conan O'Brien and his writers unlawfully used Kaseberg's jokes. Kaseberg argues that after he posted 4 jokes on his personal blog, each joke appeared in the monologue segments of O'Brien's late-night talk show, Conan. The plaintiff filed copyright actions for each of the jokes in 2015, and he calls the jokes on his blog literary works. The applications are still pending. Kaseberg is seeking actual, statutory, and increased statutory damages for the willful infringement. The court recently required the defendants to produce each piece of email correspondence sent prior to the dates that the jokes were told to determine whether the writers accessed Kaseberg's blog and actively copied his jokes. One of the jokes that he argues was infringed upon appeared in a February 3, 2015 blog post. Tom Brady said he wants to give his MVP truck to the man who won the game for the Patriots. So enjoy that truck, Pete Carroll. During his monologue on February 4th, 2015, O'Brien told the following joke. Tom Brady said he wants to give the truck that he was given as Super Bowl MVP to the guy who won the Super Bowl for the Patriots, which is very nice. I think that's nice. I do. Yes. So Brady's giving his truck to Seahawks coach Pete Carroll. Idea versus expression. In both jokes, the idea presented is that Tom Brady wants to thank the person that helped his team the most after they won the Super Bowl. The expression of the idea is that Brady would be giving away the truck to the other team's coach. When determining whether the joke is a copyrightable expression or merely an idea, the court will look at the underlying elements of the joke. In this case, the expression that Brady is giving away the prize truck to an opposing team's coach to thank the most important person who helped the Patriots is unique because there are potentially hundreds of people who helped the Patriots win the Super Bowl. Since the plaintiff's expression was so unique, it is likely that he can overcome the first hurdle to copyright applicability and can move forward in his lawsuit. Originality and independent creation. Here, O'Brien and his writers use the same 2 parts from Kaseberg's joke in O'Brien's monologue. However, the defendants might argue that the write-around they used when developing their version of the joke in O'Brien's monologue made O'Brien's joke original and therefore an independent creation. During the electronic discovery process, the plaintiff will investigate Conan's writer's prior emails and work product. The defendants claim that they did not infringe upon Kaseberg's jokes will be aided if they present emails or other evidence that they were creating an original and independent creation for O'Brien's monologue and were not using that joke from Kaseberg's blog. Merger doctrine. The plaintiff must successfully argue that the merger doctrine does not apply to the joke to proceed with his copyright infringement claim. Here, the most obvious joke that can be made is Brady wants to thank the opposing head coach for giving him the truck. This is because the opposing coach called a play that many consider ill-fated for his team and beneficial to the Patriots. Unlike the contest rules that used social security numbers to protect identity in Morrissey, which were an idea that could only be formulated in a limited number of ways, the idea that Brady wanted to give away the prize to the individual who helped the Patriots win the Super Bowl is limitless. Since the idea and the expression of the idea were not intertwined, the plaintiff can argue that the merger doctrine is not applicable here, and that the defendants had numerous ways of making a joke about Brady wanting to thank the person who won the Patriots the Super Bowl. The fair use doctrine. Similar to the analysis in McCollum, the analysis in Caseburg's lawsuit will focus on the fourth element of the fair use doctrine, whether the effect of the joke in O'Brien's monologue harms the current market for the original copyrighted material. Like Caseburg's joke, O'Brien's joke was for comedic purposes as well as commercial purposes. With such a funny joke, Caseburg sought to increase visitors to his blog to generate advertising revenue, while O'Brien and his writers sought to increase commercial revenues with a higher national program viewership with funny and timely humor. Caseburg could argue, perhaps successfully, that the market for his humor has been harmed because less people visit his online blog if they see a joke that has already been told to millions of people on national television. The potential visitors would think that the humor in his joke is stale and would be less likely to visit the blog again in the future. Fixation. Finally, the plaintiff's joke appears to satisfy the fixation element. The plaintiff's jokes are all accessible on his blog and were not removed from his blog. Because of their easy accessibility for those browsing the internet, the jokes are permanent enough in character and can be easily viewed and subsequently reproduced by others. Initially, it appears as if Caseburg can successfully assert copyright infringement of his joke. On the one hand, the joke was a permanent and unique expression, which did not merge with the idea of Tom Brady wanting to thank the person most responsible for his team's Super Bowl win. Additionally, O'Brien's joke would harm the potential market of a potential audience for Caseburg and his humor. On the other hand, if Bryan and his co-defendants can present evidence that they used their own original methods to write a joke, and that they did not access Caseburg's blog to write the joke for O'Brien's monologue, then Caseburg's copyright infringement claim cannot proceed. No matter what occurs in the litigation, this case study demonstrates the uphill climb a plaintiff in a copyright infringement claim faces. Simply put, seeking copyright protection for humorous quips is no joke.